National Insurance Clearinghouse, the marketing arm of Brokers Alliance, presents a Bravo video event, the Business Insurance Zone, dedicated to financial professionals who use insurance in their practice.
And on today's show, Basic Estate Planning with attorney Lou Shuntage.
And now the host of the Business Insurance Zone, the whiz of the biz, insurance columnist Steve Savant.
Well, welcome everyone to the Business Insurance Zone. We're broadcasting live to a nationwide audience of financial professionals right here in Fountain Hills, Arizona, home of America's largest fountain. And with me today to talk all week long on basic estate planning is going to be our attorney from Lincoln Benefit Life, Lou Shuntage. Welcome to the show, Lou.
Thank you, Steve.
Lou, the reason we're having you on today is because we're trying to look at opportunities, product opportunities. A lot of it will be life all this week. And of course, a lot of our cult following life producers are going to love that. We even have some ideas where we can use annuities as part of our estate plan. But before we get going, I wanted to go too fast and too far out. Lou and I want to talk about three docs. Three docs not only for your clients, but actually, Lou, we should have this as well as advisors. And I've always found out that if you have the same docs that you want to share with another person, and of course we don't practice law here, so it'll be his attorney, but we're going to talk about three basic docs that your client needs, that you need, and once you have those in place, there'll be other documentation we're going to talk about throughout the week. But these three are basic. Lou, talk about the first one, because I have to say, if I do a survey on this, and I might just do this, how many of our advisors have these three basic docs? And these are the basic ones that every person should have in America.
That's right. And the beauty of this is that once you talk about these three documents, they're a door opener to get into life insurance sales opportunities because they apply to everyone. The first document happens to be, I think, a durable power of attorney. You know, we all face the possibility of becoming disabled in life. In that capacity, you can't manage your property. So you need someone to be able to do that for you. A durable power of attorney authorizes someone who you choose to manage your property while you're in an incapacitated state. Notice the word durable. Mm-hmm. It's there because normal powers of attorney cease when the person who's given the power becomes disabled. A durable power, on the other hand, goes on even after incapacity until such time as death.
Now, can this be anybody? Can I be like my relative? Does it have to be an attorney? Who does it have to be?
No, you can pick anybody you want. Just has to be someone logically in whom you have confidence, who you trust, is capable of doing what needs to be done.
So let's say in my case, I pick my eldest son as an example. If something happens to me and I can't make a decision, my wife can't make a decision, he comes online and as my fiduciary now, he takes my spot and makes those critical decisions.
That's correct.
Now should I have a backup to that in case something happens to him? So how deep do I need to go on this?
I think the principal, the first person you choose, and then a substitute for them. That should be enough, one and two.
And generally, when we're looking at durable power of attorney, this is an easy doc. I've seen this out on the net. If you Googled it, you'd see it. We have that doc we have an estate planning documentation. It's a very basic, it's about 113 pages, sorry for the length, but it's there. If you want to order it, just order it on my email, thebiz@brokersalliance.com, or you can call toll-free 1-800-290-7226, extension 147, and I'll send you that. Durable power of attorney. I'm going to choose somebody. Probably, for me, I'd probably stay within my family. But let's say I wanted somebody to be more dispassionate. Who would be my next choice outside my bloodline?
You might pick a professional individual. You might pick a CPA. You might pick a trust officer of a bank as a possibility. But someone who has a professional background and whom you have confidence.
Now, when I think about durable power of attorney, this kind of leads into our second doc. I think about something medically so wrong with me that I'm incapacitated. I'm alive, but I don't have the ability to make decisions for myself.
That's the idea.
Now, what's the next doc then?
Well, you bring us right into what we call a medical advanced directive. You have the possibility that at some phase of your life you become ill or injured in a way that you can't make decisions from a medical perspective. In that case, it's important that you leave some kind of documentation and authorization where decisions can be made for you. Typically, we divide this in two parts. For those people who are terminally ill, there's something called a living will that's permitted in some states, where you say that there are certain things you will not accept in medical treatment, such as you don't want artificial nutrition, hydration that can keep you alive for years in a vegetative state. You do or do not want pain-killing drugs which might hasten your death. You do or do not want extraordinary procedures like organ transplants, breathing machines, or whatever.
So you can spell all this out.
Oh, yes. But I'm talking about a situation where you're terminally ill and you're describing just the things you do not want. Okay. Now, in those cases where you're not terminally ill and there are going to be decisions that have to be made, there's another document called a healthcare proxy or a healthcare power of attorney, where you're now authorizing someone to make medical decisions for you. Kind of like with the property situation, durable power. Here's a situation not about your property, but about your health. They're making decisions for you.
And that's a separate person, or could it be the same person as a durable power?
Could be the same person.
Okay, so if I'm going to list what I don't want to do to prolong my life, I just saw a television episode on cryogenic freezing. I was just like, could I put that in there? I went, hey, I'm not sure I want to meet death yet, so can you freeze me until I'm ready to go?
Yeah.
I mean, I guess you could, if there was technology, I guess you could say that, right?
I think so. You could, say that whether you want that or not.
So if I get to the point where I'm saying, guys, I don't want to prolong this. I don't want and this, I notice this in final expense sales all the time. People say, one of the reasons why I did final expense just to pay the last medical bills, but where I have a protracted stay in the hospital, almost a vegetation state, I just want them to pull the plug. I don't want them to waste a lot of money over and above my final expense insurance on something that looks pretty much I'm not going to wake up. So you could actually say whatever you want in there. Don't continue procedures if I'm completely vegetation. Maybe I have no synaptic activity in my brain, whatever that spells out. What kind of language do I have to use for that? Pretty specific, or?
Well, when we come to the living will situation where you're saying what you don't want, the more specificity, the better. But the big three things to think about are: do you want pain-killing drugs might hasten death? Do you want artificial nutrition hydration? And do you want these extraordinary procedures like organ transplants or whatever? I might add, when you spoke about cryogenics, that might be something better covered in your will in terms of the authority of your executive of your estate. But certainly anything you want, you should put it in writing, leaving guidelines to those who follow you.
I mean, really, when you put something in writing, sign off on it, it's verified, credible, it's your signature, it's your wish, your will.
Right.
This is what really the state's going to look at. If you don't, then we travel through probate on all these issues, and maybe even suits by some siblings who want you to stay alive and others that feel like they want to. I mean, there could be civil war within your family if these aren't spelled out.
Yeah, that's one of the ideas of doing this, is not only do you take care of receiving the kind of treatment you want or don't want, but you also relieve your family of the responsibility of getting into fights, which can destroy your family. So yes, that's a second very good reason, is that your family doesn't have problems. I have seen cases where, families have fought where, one will say, we have to prolong, how can we kill our father? Another, no, he wouldn't want to be like this. And it can really cause hard feelings.
Well, also, when I'm thinking about directives, we had one of your colleagues on about a couple of weeks ago, Scotty Pope from Lincoln Benefit Life, and Scott brought us this thing called the Facts of Life book. Now, I noticed in there, would I be able to also put in your area there, I'd rather be cremated, not buried. Can I say that, or is that in my living will?
Well, that's more a matter for your executor in your regular will. Think about the medical advance directive as dealing with medical decisions while you're alive. Once you die, I think we step into the realm of your executor in terms of what happens to your body, and that's described in your will.
And I can spell all that out.
Yes.
Okay, so that kind of leads us into our third doc. And I say this knowing that I'm going to take some email on this.
Sure.
I am shocked that I would say the vast majority of our producers, and I mean decent financial advisors, do not have a will themselves. And yet, I've seen them suggest it day in and day out to their client, which I think, of course, is the right thing.
Sure.
But they themselves are not in here. Don't we have a problem with this, Lou? Because if I'm talking about my will, I'm talking about my own demise, my termination of my life. I mean, it's kind of morbid. I mean, honestly, it's not one of the more fun things to talk about.
Well, that's the problem. People don't like to think about their own mortality. But, if you want to have credibility with your clients, don't you think you should be doing yourself what you're asking them to do or suggesting they do?
Well, I would think that, we always tell people, I did this when I was raising my kids, I always say, do what I say, but don't do as I do. Right. But in this case, I think one of the things that I've seen as a sales tactic, and this is going to be our whole week when we talk about 15 different life and or annuity sales that have to do something connect with estate planning at the basic areas that we're talking about today. And I'm telling you that basic ideas like durable power of attorney, right? The medical advance doc, having a will, all these actually are precursors to sales.
That's
And
right.
if you would use this right, these are great introduction because everybody's guard is going to be, oh, down. Well, I should do that. Oh, yeah, I probably should say who should be the power of attorney. Yeah, I probably should pick somebody on the medical advance doc and say, put all my heartfelt desires down, what I want or not want. I think that everybody gets that, and that discussion should be had, even though, again, it could be a little bit morbid. But I think that's a great pre-entry to a life sale or an annuity sale, depending upon what we're going to talk
Sure.
about this week. So when you see clients, and Lou, you've been in this, I mean, how long have you been doing this?
Long time.
So, okay. Well, he didn't want to tell us how long, okay? I usually try to set that as how veteran are you in the business. But I guess what I'm saying, you've seen so many times, people just don't have these docs. Is that not so?
That's true.
Now, give us I'm just kind of curious, a basic, what do you think a price tag would be if you're just doing a basic will, basic power of attorney, basic medical advance doc? What does that cost, would you say? Is it all over the board? Or?
Yeah, that's closer to the truth. What you have to realize is that in different parts of this country, legal fees vary. They vary from attorney to attorney, depending upon the amount of experience and training they have. So we can go all over the lot. The first thing a person should do when they speak to an attorney is get some idea, a ballpark figure of what they're getting into, and then ask for an itemized statement. Also, when you go to see a lawyer for your estate planning, there are certain things you should take with you. And that would include, for example, any existing documents you have, wills or trusts, durable powers, medical advance directives. Take all that stuff with you. Take the information you have on your insurance. Take information you have on your major assets, your homes, your other investments. As much you can take with you so the lawyer can see what your assets and liabilities are and how things are owned. That becomes very important. Remember this, when you go to see a lawyer, their time is money. So the more time you can save, the more money you're probably going to save. But first of all, talk about cost.
So really, before we even talk about these three, because we want to keep the attorney costs down, no offense, Lou,
Sure.
billable hours are a big deal with these kind of guys, so you just got to be heads up on that. But I'm kind of looking at, if I went down a data gathering collection kind of, siege in my house, I got to go pull all these docs together, get all my assets, all my annual statements together. And by the way, this sounds like a great idea to review life insurance, their policies, because I'm going to have to look at it anyways, and that becomes a big part of the assets at death. Because we always think home, retirement, but your life insurance, $500,000 to $1 million, that may be a big chunk of your money.
Not only that, but how is it owned? Who are the beneficiaries? Many times people make mistakes on those two areas. So it pays to actually sit down and review that and you make your final plans.
Hey, when we come back from this break, I want to talk exactly about mistakes, because I think we could quantify who's supposed to be the owner here, who's supposed to be the actual insured, who should be the beneficiaries and contingent beneficiaries. And I think we make mistakes like this all the time. Look, I'm surprised. A lot of our guys have been in the business for 20, 25 years, and we still see these kind of mistakes. When we come back, I want to talk about that. Well, you're listening to the Business Insurance Zone, the talk show that talks about insurance in your practice. You can write me at thebiz@brokersalliance.com or call us toll free, 1-800-290-7226, extension 147. Lou and I will be right back after a word from our premier sponsor, Brokers Alliance, a leading authority on product distribution on insurance.
Whether you're a professional planner pursuing a strategic partner or an insurance distributor seeking a national alliance, your business just went into overdrive. Now enter the largest resource of insurance products and services with unparalleled access to a worldwide audience of consumers through the National Insurance Clearinghouse, the marketing arm of Brokers Alliance, who can take your company and launch it into the stratosphere of success. With countermeasures, the most comprehensive carrier intel in the industry, the MASH unit with field triage underwriting and the premium tolerance test, the life insurance financial evaluation, the most rigorous policy review, and Bravo high definition broadcasting with online social media. Your search just ended.
Well, welcome back to the Business Insurance Zone. I'm Steve Savant, your host, insurance columnist, financial color commentator, and in my own eyes, interviewer extraordinaire. Remember, before moving forward with any of the strategies, especially on this show, Always talk to your CPA, your tax attorney, and if you're FINRA licensed, your broker-dealer compliance department. You can call us for any quotes or questions that you have on life insurance, annuities, DI, LTC, group pension plans. 1-800-290-7226-147. It's not what I know, it's who I know, and that's why I have Lou on. Lou Shuntage from Lincoln Benefit Life, attorney at large, visiting our show today. And you know, Lou, just before the break, we kind of snuck into a wheelhouse issue we have here at Brokers Alliance, and that is, you said, we're reviewing life insurance. And I was like, I panicked for a moment because I'm thinking, man, I see a lot of mistakes during this on who should be the insured, who should be the beneficiary, contingent beneficiary, who should be the owner. Let's talk a little bit about that, because that is a major critical issue and kind of like the idea of that lawsuits are made of.
Yes. I tell people, when you're in the insurance business, it's your prerogative to recommend the kind of insurance and amount of insurance someone should have. It's also your prerogative in pursuing that to look at the basic information about this person and figure that out. But when it comes to making recommendations about ownership of the policy and who the beneficiary should be, that has such a dramatic impact on the end result that these are things they should review with their other advisors like the lawyer or the CPA. And as I said before in our prior broadcast, oftentimes people are mistaken in terms of who the actual owner or beneficiary of their policy is. I recall wrote an article I titled, Is a Rumpelstiltskin? Playing off the fairy tale where, if you guess somebody's name, Rumpelstiltskin, you get a prize. In real life, this should not be a matter of guessing. You need to know who the owner, who the beneficiary is, and in fact who it should be to accomplish your goals.
Well, that leads me to my next question then. Is there any rule of thumb for ownership? Because he who owns is who's going to pay whatever tax if there is an event. So is there an issue there? Like, let's divide it into two camps. I don't have a big estate. Let's say it's under $5 million. Not that we'll get into that a little later because I still think there's issues here. But let's just say for safety's sake and basic ideas, I don't really have a big estate, okay, but I have a life insurance contract. Should I own it? Should my wife own it? Does it matter if I'm in a community property state or a non-community property state on ownership of life insurance? Let's tackle that first.
All right. Let me say this to you. This may sound funny coming from a person with a background as a tax lawyer, but you should do nothing just for taxes. Rather, you should do what you should do and what you have to do to take care of yourself and your family, and then with proper planning, we do it at the lowest tax cost possible. Now, flexibility is also very important in planning. So if you've got an individual who doesn't have to worry about a taxable estate, there are other modest means, then when it comes to dealing with insurance, you can retain ownership of it because you're not concerned about estate taxation. Owning a policy gives you the flexibility of deciding who's the beneficiary is going to be, what you do with the cash values of the policy while you're alive. So if tax is not an issue, ownership is something to look at because of the flexibility it gives you. If you're in a situation where your estate is large enough, and who knows what the future of the state tax is, but if it's a substantial estate where taxes might be a problem, then typically you find ownership not in the insured but in a third party. That third party can be a member of the family, or it can be an irrevocable life insurance trust. I typically recommend trusts to people because of the fact you have a more certain result. If you have ownership owned by a child, a policy, for example, what if the child gets divorced? What if they die? What happens to the policy? You don't know.
Well, Lou, let me just ask you, let me stop you there, because we're broadcasting out of Arizona. We're a community property state. You live in Florida, is that a...
Yes, correct.
Okay, well, so we're both on the same page on this. And I'm just curious, because of divorce alone, let's just talk about that for a second, just on the basis of divorce, to have some control. And I'm thinking of women. I just wrote an article a couple months back on this about your spouse died, and with it your income, and that's a major issue in a community property state. Is there any advantage of doing cross ownership? I own my wife's own. Is there any, or not really, or except for the issue of divorce?
I think it all really comes down to a matter of what are you trying to accomplish. That always has to be the first question. What are we trying to accomplish? And then we, how can I say, massage the transaction to fit our goals, our needs. One caution I will give, if you're dealing with a community property jurisdiction, you have to understand that income that comes from that community is going to be a factor in an insurance situation. So for example, you could set up a trust, which is an irrevocable trust. You could make your spouse the beneficiary of that trust to take care of them. and you're paying the premiums on that policy by making gifts to the trust using community funds. What you might not think about is the fact that you may cause that insurance to be in the spouse's estate. Why? Because the spouse is a beneficiary of the trust, and since the money going in as gifts to pay the premiums is community money, that spouse has also been a grantor of the trust. Well, if you're a grantor of the trust and you're a beneficiary of the trust, what's in the trust is in your estate. So you've got to be careful. You know, when you play with these kind of things, again, what's your goal, what you're trying to accomplish, then you massage the transaction.
Yeah, I think this is a huge issue. Many of you have been watching us for a long time. You know that we do a life insurance policy audit called the Life Insurance Financial Evaluation. To me, this is a huge issue going forward. Especially if we don't have real serious taxable issues, we might want to set the true and proper ownership on the next contract and fix this. And we have seen over the 30 years that I've been in this business, about a third of everything I see, especially on the annuity side, wrong ownership, wrong person being the annuitant. Everything that we wanted to have happen does not happen. This is a huge issue. So if you say, Steve, I have policies on my books, and I don't want to have an E&O issue here, maybe I ought to review it. Or you're reviewing somebody else's book of business. Maybe you purchased a book of business lately. I want you to think about it. You can call me 1-800-290-7226, extension 147, or write us here at the show, thebiz at brokersalliance.com, and we'll do a complete review for you, and then we'll check with our strategic alliances that we have with carriers like Lincoln Benefit, and we'll say, hey, is this what we should be doing? And then they'll check it for us. We're going to have third-party substantial legal authority look at this because ownership, beneficiaries, and the insured are critical so that we understand, hey, did we actually do what we should have done when we actually titled the insurance property? It is personal property, by the way. So, you know, we need to title it right.
Think about this, too. When you're doing an audit of a person's insurance portfolio, there are three circumstances where you really need to take a close look. First of all, the change in family circumstances. Think marriage, divorce, birth, death. Second, the circumstance involving the person's employment. Did they change jobs? Did they lose their job? Did they retire? Did they buy a business? Did they sell a business? And thirdly, finally, changes in the law, which are most typically changes in the tax law like we had in 2010, and we may have again this year. Any one of those three, you better take a look. I would say even beyond that, automatically every couple of years, people should look at their coverage.
I think that we talk about annual reviews on the show all the time, which is a given. But now we have a better reason because we were doing annual reviews solely on the basis of, hey, new product upgrades, medical technology and underwriting's changed, maybe your issues of your client has changed, maybe their situation has changed. Now I'm questioning, gee, I wonder if we got the ownership right. I'm wondering if we got the beneficiaries right. I'm wondering if we should have the right insured on there. We want to look at these things, and again, if you want to send it in to us, just write us at the show, thebiz at brokersalliance.com, or just call toll-free 1-800-290-7226, extension 147. Lou, when I'm talking about documentation, you mentioned it already. You talked about an irrevocable life insurance trust. Every time, and I have to say this after my 30 years being in the business, every time I hear the word irrevocable, it's like, that sounds like I just put myself in a concrete straitjacket. You know what I mean? Sure. There's no flexibility. I hear revocable trust, irrevocable trusts, right? And I always wonder, what is the, I hate to be a kind of a hair splitter here, but I always wonder, is it irrevocable or irrevocable?
Irrevocable, I think.
Okay, well, that's the Floridian talking, so we'll have to see. But when I hear irrevocable life insurance trust, I sometimes freeze because it sounds like I just limited, because you were talking about access, flexibility, liquidity, and then I hear the word irrevocable.
We can put in flexibility, and that's
the trust.
Yes. There are two things that we want in estate planning, and that is, one, certainty of result, and secondly, flexibility to face a change. Life insurance, particularly with secondary guarantees, can give us a certainty of result. Flexibility to face a change, well, when we start talking about irrevocable life insurance trusts or ILITs, we're going to use that kind of a document to hold the insurance because we want to keep the insurance out of the person's estate. That's usually why ILITs are used. Now, when you say that, most people, when hearing the word irrevocable, it makes them sit back and be concerned. But we can build flexibility into the trust itself. For example, we can give the individuals, if she's not insured, let's say it's a husband insured, wife, spouse, we could give her a special power of appointment. By that I mean she would have the ability to tell the trustee, look, take a withdrawal from the policy if it permits it, do a loan, surrender, whatever, and we can take that money and we can have the trustee give it to a beneficiary of the trust, such as one of the children. Okay. Now you can't agree ahead of time that they'll do it, but if need be, the child could then turn around and, as long as it's not a done deal, give the money back to the parent.
And that's okay. I mean, that sounds like there is an incident of ownership or some kind of constructive receipt.
Now, as long as it's not a done deal, understanding between the child and the parent that the child will give the parent back the money, all right? The child's an adult, we're going to use an adult. They have a mind of their own. They don't have to give the parent back the money if the trustee gives it to them. So that's not going to cause inclusion. Next thing is, we could write, I think, in the trust that the trustee has the authority to make loans to the insured, okay? As long as they charge interest, and it's properly documented, I do not think that's going to cause the insurance proceeds to be included in the insurer's estate.
Well, I mean, that sounds like there's a little bit more flexibility because that adjective, irrevocable or irrevocable,
Yes.
sounds like a kind of finality kind of a statement, but it isn't. You can actually put in wording that'll give some kind of flexibility,
Yes.
liquidity, and access back if the grantor actually needed it in this kind of roundabout through the beneficiary way, if I heard you
That's
if I
correct.
understood. Well, I'm thinking when you say, Steve, I really don't understand any of this, we have complete docs, easy to understand educational material on irrevocable life insurance trusts and powers, crummy powers. Boy, there's a whole subtitle. We'll get into that tomorrow. All these things we have for you, just write us, thebiz at brokersalliance.com. I'm happy to send you any docs on this, absolutely free. Well, you can watch our show and all the shows this week on basic estate planning in beautiful HD 1080p right on our website, www.brokersalliance.com, and of course on all our social networks, YouTube, Vimeo, Facebook, LinkedIn, and where I tweet, Twitter. This is Steve Savant. You've been listening to the Business Insurance Zone. That's the buzz on the biz for today. Get in the zone, the Business Insurance Zone.
This has been a Bravo video event of the National Insurance Clearinghouse, the marketing arm of Brokers Alliance, one of the largest distributors of insurance products and services to a nationwide network of insurance professionals. Need insurance guidance? Call Brokers Alliance. The Business Insurance Zone, dedicated to financial professionals who use insurance in their practice.